Hey everyone, my name is Corinne Blaylock. I'm the Executive Director of the LPE project. Thanks so much for joining us. As you know, we had hoped to gather together in person last April for the Democracy Beyond Neoliberalism conference. However, we are thrilled to be hosting this virtual conference series and grateful to everyone for making it possible. Our entire lineup of events and registration links, as well as a sneak peek of what's coming up on the blog, are available through our website, lpeproject.org, where you can also sign up for conference-specific updates and reminders. Our next event, The Political Economy of Motherhood, Race, Poverty, and Non-Equal Rights with Wendy Bach, Jessica Dixon-Weaver, Cynthia Godso, and Julie Sook will take place next Wednesday, March 17th at 6 p.m. The project is thankful to the Columbia Law School LPE chapter for helping to organize this event, and it is my pleasure to introduce today's student moderator, Ella Epstein, who is a 1L at Columbia Law School, where she matriculated upon completing an undergraduate degree in economics at Columbia University. All right, it's all yours, Ella.
Thank you so much, Corinne, and thanks to all the panelists for being here and for everyone joining us virtually. It's, of course, a shame that we can't gather in person, but we're especially grateful to you all for taking the time out of your days to be here. So we want this to be as close to a free-flowing discussion as possible after the presentations. So please submit your questions for the panelists to us through the Q&A function so that they don't get lost in the chat, and we'll get to as many of them as we can after the presentations. So I'll start off by introducing the wonderful panelists with us today. In the order in which they'll present, starting with Professor Sanjukta Paul. Professor Paul is an Associate Professor of Law at Wayne State University. She researches at the intersection of labor and antitrust law. Sandeep Vaheesan is the Legal Director at the Open Markets Institute. He writes about a variety of topics in antitrust law, including the relationship between antitrust and workers and the political content of antitrust. Luke Herrine is the Managing Editor of the Law and Political Economy blog and a PhD candidate at Yale Law School. His current research focuses on the history and political economy of American consumer protection law and on laying the theoretical groundwork for post-neoliberal legal analysis. Professor Marshall Steinbaum is an Associate Professor of Economics at the University of Utah and a Senior Fellow in Higher Education Finance at Jane Family Institute. His work focuses on inequality, antitrust, labor markets, the intellectual history of economics, and higher education policy. Finally, Kate Redburn is a law clerk on the Second Circuit Court of Appeals and a PhD candidate at the Department of History at Yale, specifically in the program on women, gender, and sexuality studies. Their research is at the intersection of legal history, gender and sexuality, and political economy. So before we get started, this panel is called Moral Economy After Consumer Sovereignty. What exactly does that mean? Modern use of the term moral economy originates with the work of historian and sociologist E.P. Thompson. He introduced the term to refer to ways of understanding the moral logic of market governance that predated the rise of capitalism and the classic political economy that emerged to justify the commercial society capitalism brought with it. In his keystone work, The Moral Economy of the English Crowd, Thompson argues that early modern market governance, quote, operated within a popular consensus as to what were legitimate and what were illegitimate practices in marketing, milling, banking, etc., which in turn was grounded upon a consistent traditional view of social norms and obligations. In particular, moral economy logics pivoted around ideas of fair price and fair dealing, and an effort to direct transactions into public market spaces in order to avoid middlemen controlling supply or speculating, or sellers adulterating goods or manipulating weights and measures. These norms were especially binding in grain markets, which were essential in a society dependent on its daily bread, and especially during times of shortage, when sellers had extra incentives to raise prices and middlemen had extra incentives to try to hoard grain for profit. As these norms began to break down with the increased power of merchants in early capitalism, riots would break out in order to enforce the price that would have traditionally been set, thus applying a selective reconstruction, in Thompson's words, of the traditional form of market governance that took from it, quote, all those features which most favored the poor and which offered a prospect of cheap corn. Smith, Ricardo, and other founders of classical British political economy were opposed to these institutions and reasonings of this older moral economy. They introduced the idea of markets which operated according to a special kind of self-equilibrating logic, a logic that often obscured capitalists' increased control over the institutions of market governance and disdained any appeal to publicly impose norms of fairness. According to this way of thinking, everybody, including those consumers of grain or other goods, would be made as well off as possible if the market were allowed to self-correct through a price mechanism until supply met demand. So moral economy regulations that previously prevented grain dealers from charging high prices during times of shortage were, according to this new guard, misguided. Even as English market governance moved away from traditional moral economy forms, authors such as William Novak have shown that many moral economy ideas and institutions moved across the Atlantic with the British-American settler colonial project and remained firmly in place until the disruptions of the Second Industrial Revolution, starting in the middle of the 19th century. One theme of today's panel is that certain parts of the modern US regulatory state that responded to the Second Industrial Revolution are derived from selective reconstructions that populists and progressives made of older forms of moral economy. Learning from these selective reconstructions might help us think about how we may perform our own. Looking to earlier reforms might also help us critique our modern methods of market governance. One way to understand neoliberalism and its ideology of consumer sovereignty is as a reaction to the institutions and intellectual traditions of early 20th century moral economy. At a discursive level, many of these neoliberal reactions took the form of an updated version of the classical understanding of markets as self-equilibrating, hence neoclassical, again, obfuscating capitalist accumulations of power, often in the name of disempowered consumers. But as we will explore in the panel today, neoliberalism has a more complicated discursive repertoire that draws on other rhetorics of reaction as well. Today's panelists will explore different aspects of this history and what it might teach us about how to think about the ways market governance does work and might work for those of us seeking to move away from self-equilibrating logics of law and economics. So let's dive right in, starting with Professor Paul, turning it over to you and your presentation. Thank you.
Hi, everyone. Can you all see and hear me? Okay. Great to see. I was just scrolling through the participants. Great to see you all. I hope I don't just repeat things that you all know already. So I'm going to start just by orienting a little bit. So I'm going to talk about antitrust law. I know a couple of other panelists are as well. Antitrust law is, of course, the area of law in which neoclassical welfare economics is most securely enthroned as the framework for thinking about law and policy. So I would say that antitrust law is important for the LPE project in its own right as an affirmative project for thinking about democratic and moral market governance, but it's also important because its very status and reputation within law as economically sophisticated has lots of effects on other areas of law and policy, notably upon labor law, and also on local and regional policy and frankly, even federal policy to stabilize markets and to support fair prices and wages. So this is true, I think, both in a more diffuse social and institutional sense, and also in a pretty straightforward jurisprudential sense, given the status of the antitrust statutes as so-called super statutes, as scholars like Bill Eskridge have called them. So I'm going to start with that orientation to why talk about antitrust in this particular panel. I think there's kind of those two related reasons. I'm going to go off script just a tiny bit, off script by talking a little bit about the legal allocation of economic coordination rights. Off script, but on brand, perhaps creating brand-wide efficiencies, turning this panel into a singularity rather than a cooperative enterprise of producers. No, we don't want to do that. So the basic thing about economic coordination rights, in addition to ideally giving us a way to think in a unified way about what various areas of law do, what the law of corporations does in terms of allocating coordination rights within business enterprises, what antitrust law does in allocating coordination rights across markets, and to some extent also within enterprises, and what labor law is supposed to do in partially allocating coordination rights, both within enterprises and if multi-employer bargaining is established, then also across markets. In addition to giving us a way to think in a unified way, I think about those as a connected project rather than separate, potentially conflicting projects, I think that the basic thing about it is that once we ask how antitrust law allocates economic coordination rights, we see that it is allocation of coordination rights all the way down. There isn't some other core set of legal rights at the foundation that can be derived, for example, from neoclassical microeconomics that can then serve as that foundation to build up other more contingent choices. On the contrary, the very units of analysis assumed by neoclassical welfare economics, namely firms, or at least microeconomics, namely firms or enterprises, are themselves constituted by irreducibly legal decisions about economic coordination, decisions that have no fixed or independent content beyond ultimately currently arbitrary convention, which, as I argue in other work, happens to favor hierarchy and control in less or more systematic ways. And that is also why I spend as much time as I do talking about this idea of the firm exemption. It is in part to denaturalize conventionally organized firms and open up space to consider other forms of economic organization, from more democratic firm structures to specifically worker-owned and run firms to looser and interdependent coordination among producers or providers of services. But also, I think it's important to talk about the firm exemption because the notion that the firm is a singularity is on some level presumed by neoclassical analysis, yet not explained by it. And it is, I would say, an indispensable foundation stone for the whole enterprise, for the whole analytical enterprise of law and economics analysis, at least in antitrust law and those adjacent areas of law that I mentioned, that we're interested in questioning and hopefully replacing as a part of this collective project. And I would also say that I think that this extends, but goes beyond the standard legal realist critique of laissez-faire that we're familiar with from the early 20th century, because a topic to be left perhaps for another day, that as a whole, I think that that critique focused largely upon distribution and leaving alone and frequently even endorsing classical and emerging neoclassical accounts of production. But I think that in thinking about the allocation of coordination rights, we are talking fundamentally about production and ways of organizing production as well as distribution and consumption. And so once we recognize that it is sort of, so everyone may not be quite on board with that, but others may think that, you know, this is sort of obvious. Once we do recognize that it's sort of these decisions about economic coordination all the way down with no independent answers to be supplied either by neoclassical economics nor in more common sense folk principle in favor of competition, full stop. That cannot be the only organizing principle. Once we recognize that, even though promoting healthy competition certainly may be, and I would say should be, one criterion for allocating coordination rights, then I say we get to moral economy. And moral economy as sort of a historically specific tradition that Ella so nicely described, and also as a framework that I think we'll talk about perhaps in the Q&A that can be generalized from that. And I think that central to that, I would say, are the dispersal of economic coordination rights and notions of fair competition and fair dealing, which are already very historically rooted in the tradition. And I think Sandeep is probably going to talk a little bit more about what specifically norms of fair competition and fair contracting could look like. But so moral economy as this historically specific tradition was indeed mainly about consumers, but is generalizable to producers and to production as well. Indeed, the notion of just price, which is central to moral economy and of course goes back further than the 18th century, much further, was meant to incorporate both producer and consumer perspectives. As E.P. Thompson himself put it, the old, quote, old moral economy of provision, unquote, and the traditional organization of, quote, industry and trade, unquote, are unified by this idea of just price. And Thompson himself said, quote, the consumer defended his old notions of right as stubbornly as perhaps the same man in another role, he defended his craft status as an artisan, although that mostly took place in the 19th century, at least in the US, rather than in the 18th century. So I think that sort of we won't, I think that the background in terms of the 18th century consumer movement was already quite well described. I'm just gonna say a couple of brief things about moral economy and antitrust, which I see appearing in sort of three different stages. The common law restraint of trade, which is considered to be sort of the common law precedent to to federal antitrust law in the anti-monopoly movement that agitated for federal antitrust law, and in the Sherman Act legislative history. And I'll only briefly mention these things. They're further described in the paper that is linked on the conference website. So this, and just briefly, I won't talk about this too much, but the common law restraint of trade as precedent for federal antitrust law is important, I think, both in itself and affirmatively, but also because that connection with the common law is conventionally taken to be the basis for what I call the common law statute thesis about antitrust law, which says that the Sherman Act and then somehow by extension all future antitrust statutes delegated, fundamentally delegated decision-making power to the federal judiciary. And by using, and the way that this is connected is because the language in the Sherman Act, and specifically in Section 1 of the Sherman Act, is supposed to be very broad, in referring to restraints of trade. And this is supposed to be a signal that the judiciary was being directed by the legislature to engage in common law style decision making. And I would say that the common law statute thesis has really taken on its modern form from the 1970s on, and has been bound up with the Chicago School Project in antitrust in fundamental ways, and make that case further in the paper. So anyway, it turns out the restraint of trade doctrine, as it actually existed in the common law, was fundamentally bound up with this notion of moral economy that E.P. Thompson described in very specific ways. And so the ancestors of antitrust law, doctrines such as forestalling and regrading and engrossing, were the tools that consumer movement that Thompson described used, and the very notions that they invoked. And the fundamental point, if you look at the 18th century price fixing cases, is that they revolved around a socially set price, whether for good or ill. I know that Kate is going to talk more perhaps about the dark side of moral economy, and so I think we want to acknowledge that up front. And I think we can see it even in the roots. So there's, on the one hand, the sort of collectively set price, and the judiciary, to some extent in the 18th and the early 19th century, and sort of stops in the early 19th century, accommodating this rural movement of the English rural poor as qua consumers, right? The judiciary, to some extent, accommodated that movement, but that's in one sense of the socially set price. At the same time, affirmative wage statutes in the 18th century, which also in some way, the guild structure and all of this is part of the moral economy as well, again, for good and ill, right? Wage statutes frequently were the predicate for coming down upon organizing among sort of journeymen come workers in this sort of early phase of industrialization. And that too was about deference to a socially set price or wage. And that's the earliest labor conspiracy cases that then come onto American soil and ultimately influence the interpretation of the Sherman Act against the emerging labor movement. So I feel like I might be over time. So I won't say too much, but the anti-monopoly movement, which is sort of this farmer labor coalition that agitated for federal antitrust legislation, is itself, is very much invoking moral economy ideas through this process of selective reconstruction. So definitely not the labor conspiracy part of it, but the aspects, the more egalitarian and democratic aspects. And then finally, we see, and I argue in the paper, that we see this in the legislative history itself, and we see the idea of just price invoked. And so we shouldn't view this as this delegation of power to the judiciary, and rather we can see that there's criteria for organizing the economy that are already present in the legislative intent.
Fantastic. Thank you so much, Professor Paul. We're going to move on to Sandeep Vaheesan now. Thank you.
Great. Thanks so much, Ella. It's great to be among friends talking about this interesting topic on a Friday afternoon. So I'm going to be discussing my forthcoming a law review article that I've co-written with Matthew Buck called Non-Competes and Other Contracts of Dispossession. So Sanjukta talked about hierarchy and control, and I think that's really one of the defining features of contemporary contract law. So what's the neoliberal wisdom on contracts? Contracts are private realm defined by autonomy and competition, whether it's in the consumer context, employment context, or small to large business context. This is classically embodied in 1L law school courses as the offer acceptance consideration model, a reciprocal exchange of promises. And in this model, approximate equality is in the background. It's often not explicitly addressed, but it's often implicitly there. So the cases involve customers and small firms, and 1L curriculum often relies on stylized examples, both of which obscure the corporate character of our contemporary economy. So in this model, if you agree to a contractual term, you're bound by it because you made a fully informed and deliberate decision to abide by the terms of the contract. Of course, we don't negotiate or bargain over most contractual terms these days. So the neoliberal model presents a ready alternative, that of competition. Competition serves as magical disciplining force. And I think it's nicely embodied in a 1996 decision authored by Judge Frank Easterbrook called Pro CD versus Zeidenberg. So he says, competition among vendors, not judicial revision of a package's contents, is how consumers are protected in a market economy. Pro CD has rivals which may elect to compete by offering superior software, monthly updates, improved terms of use, lower price, or a better compromise among these elements. So competition is this magical force that disciplines overreach by sellers, employers, creditors. So for instance, take the wireless market. Under this model, Verizon and T-Mobile compete not just over rates and data plans and phones, but also on terms in the fine print. So the threat of defection by a critical mass of customers or workers disciplines powerful corporate actors. And in this ideology, restrictions on contractual terms are paternalistic. Legislators and bureaucrats are overriding the deliberate, conscious choices of parties to the contract. I think this model is wildly out of touch with reality. I would argue that contracts actually function as corporate regulation. So as a threshold matter, the state stands behind all contracts. To borrow from Shelley versus Kramer, the case that famously struck down racially restrictive covenants in 1948 on constitutional grounds, the state in contracts is willing to lend its full coercive power to the party that's seeking to enforce against the breaching counterparty. So this idea that contracts are purely private agreements is false. The state stands behind contracts. Furthermore, the state decides what types of relief are available in the event of a breach. Courts have generally said that the default remedy in breach of contract is compensatory damages, and that liquidated damages and specific performance are exceptional remedies available under only limited circumstances. So from this perspective, I would argue that corporations use contract to exercise power over workers, consumers, and small enterprises, and specifically use contracts to reallocate duties and rights in their own favor. So why does this basic inequality exist? So under existing arrangements, a customer needs a wireless provider, a worker needs an employer, a small business needs a lender more than the counterparty needs them. I think this is most stark in the employment context, where for many workers, the choice is employment on one hand, or poverty, homelessness, and potentially even starvation. So inequality is the norm under present legal and political institutions. And of course, this inequality is compounded by pervasive oligopoly and monopoly power in our economy. So what about sectors of the economy that are unconcentrated and appear quote unquote competitive? Can competition protect us from draconian terms in the way Judge Easterbrook said in the late 1990s? I would say no. And the reason is most standard form contracts are obscure to us. We don't really think about them. We don't have the time to think about them, let alone engage in comparison shopping over whether Amazon includes a mandatory arbitration clause and Barnes & Noble doesn't. I realize it's a somewhat dated example, but that's what came to mind. So to illustrate that point, a 2008 study found that reading privacy policies carries cost and time of approximately 201 hours a year per American internet user. So this was more than a decade ago, and just look at one standard form contract that we commonly confront. So if we take the sum total of standard form contracts in our life, we'd probably have to devote most of our waking hours just thinking about these terms. And I think the CFPB's 2015 study on arbitration clauses in consumer finance contracts also offered useful insights. So the study found that over 3/4 of those who said they understood what arbitration is, so these are the people who thought of themselves as relatively savvy and sophisticated, 3/4 did not know whether their credit card agreement contained an arbitration clause. Of those who thought they did know, more than half were incorrect about whether their agreement actually contained an arbitration clause. And when asked to list all the factors they had considered in choosing their current credit card, not a single customer mentioned arbitration or dispute resolution as factoring into the decision. So arbitration and other standard form contracts are simply too obscure for most people to think about, let alone engage in sophisticated comparison shopping, as Easterbrook and other proponents of law and economics claim. So what are some examples of standard form contracts or contracts of dispossession that we commonly phrase? So in the employment context, non-compete clauses are ubiquitous. Tens of millions of workers are presently bound by them, and they specifically restrict our post-employment mobility. They typically have 3 components: time, space, and activity. So for instance, a hospital chain can prohibit a nurse for 18 months after leaving from accepting work within a 50-mile radius of any of the hospital chain's facilities. They're in virtually every line of work. The one notable exception is law. State bar associations generally hold that lawyers cannot be compelled to sign an non-compete clause. So we're at least looking after our own. And these appear to be classic contracts of adhesion. Very few workers attempt to negotiate or resist non-compete clauses. So in the consumer context, small business and employment context, arbitration clauses are everywhere. So corporations force consumers, workers, and small businesses to pursue dispute resolution claims in private arbitral forums. And they often contain class action waivers that say that all claims must be pursued both in arbitration and on an individual or bilateral basis. So the practical effect is an economically feasible collective litigation is turned into a futile individual action. So individual plaintiffs are forced to spend thousands or tens of thousands of dollars on lawyers, experts, and discovery to recover what may be only a few $100s. The last example I mentioned is confessions of judgment, which are probably somewhat less known than the 3 examples I've discussed so far. So these are terms that require debtors to waive their right to defend themselves in court and raise any legal defenses against a creditor or debt collector's lawsuit. So the creditor circumvents the judicial process, can directly obtain a court order to recover outstanding principal, interest, and fees, including through bank account garnishment orders. So this is an interesting area because in the early 1980s, the FTC actually prohibited confessions of judgment in consumer credit contracts, but these contracts persist in small business lending agreements. Bloomberg did a great article about the use and abuse of confessions of judgment about a year ago. So they're still very common in small business, even though they've been outlawed for consumers. So I'll wrap up by saying, what does this mean for law and policy going forward? We really need to think of freedom of contract as a special case. It's not really the default in the American economy today. It's really the exception. And the default is actually corporate regulatory power through contract. And so Congress and regulators like the Federal Trade Commission and Consumer Financial Protection Bureau should really pursue a root and branch reconstruction of antitrust law instead of piecemeal reforms targeting this clause or that clause. So I would argue going forward, the right approach for Congress and regulators is to ban common terms or even outlaw standard form contracts entirely and supply standard terms of dealing through legislation and regulation in accordance with public values and morality. So think of things like minimum wage laws, interest rate caps, liability protection on credit and debit cards. So we really need to remake contract law if we're serious about ensuring that corporations cannot use contracts to deprive us of our rights to autonomy, our rights to a day in court, redress for wrongdoing, and due process. Thanks.
Thank you so much. We're going to move on to Herrine now. Thank you.
Thanks, Ella. Excited to be here. So I'm going to talk a little bit about moral economy versus economics or political economy in historical time, and whether and to what degree it makes sense to think about these as phenomena that exist across time versus a specific historical phenomenon and how that relates to consumer protection law, specifically the consumer protection movement in the United States. So one way to think about moral economy is to sort of take Thompson's description of 18th century grain markets and think more broadly about the overall regulatory framework in which it fit, and say something like, this represents and map it onto Aristotelian and Thomistic concepts of, morality, and then say like, this is a sort of like traditional form of market governance. That's what morality is, right? It's a sort of historically specific form of market governance. And maybe even one might make certain claims about, that it's common across pre-modern societies or something like that with some variations. But, and on this sort of view, markets have a relatively constrained space. Most goods and services are produced within the household and or within a community and shared. A relatively limited amount of goods are bought on markets, and markets therefore are somewhat, the moral logic of markets are then downstream from broader moral logics of reproducing tradition and social position, customs. So prices and practices in markets are themselves traditions embedded within another set of traditions. And I think that's just too limited a conception, in part because it doesn't allow us to track how that moves forward in time. I mean, it makes sense if we view social norms as somehow, repressing the market, right? The sort of competitive forces of the market that would allow, that has its own internal logic, that is then revealed, as you clear away these outdated norms, suddenly the market emerges and everything goes either where it's supposed to go or just, where a gravitational pull or whatever the metaphor is. But if we view the market as always constructed and subject to moral norms of a community, and that takes different forms in different contexts, then we need to account for how norms regarding social position, honor, proper distribution of goods among people, fairness, and the like shape people's understandings, shape people who participates in markets' understanding of what they're doing, and shapes the governance of that market itself in an evolving way. So their norms of fair price and fair dealing actually are always somewhat in play. And then this maybe is a little too broad though, because, from this perspective, any form of everything is always moral economy. Even the Chicago school is engaged in moral economy. And part of me wants to say there's some reason to maybe just say that and accept that. Because for instance, as William Boyd and other people who have researched moral economy traditions have shown, there's many basic elements of political economy that have intellectual lineages in the traditions that in the moral economy traditions, it just took on it's sort of like a one stream in understanding how the moral logic of markets work. But I think it makes sense to identify a narrower form of moral economy that is not so narrow as to be historically specific and indeed sort of essentialize one historical era or dehistoricize it. But also is not so broad as to include Chicago School of Economics, or at least allows us to differentiate it as a separate stream. So I want to separate those theories that think explicitly about markets as spaces of governance and individuals, participants in markets as moral actors, rather than thinking of markets as self-equilibrating spaces. And then the moral analysis happens that, once an equilibrium is reached, then you can look at the outcomes and look at both the allocation and the distribution, and then that's your relevant moral analysis. And so in consumer protection terms, a moral economy tradition would see consumer protection more in terms of making a market reflect a certain set of values, and a political economy, or what I'll call political economy vision, would see it more, maybe a welfarist vision, would see it more in terms of ensuring that rational choice guides markets. And this, you can trace it all the way back to the tension that Ella talked about in her introduction in the 18th century grain markets, right? From the very beginning, Adam Smith is saying, markets, the ultimate purpose of markets as consumers is, making consumers better off. And from the very beginning, the notion is that the real way to protect consumers is to allow sort of consumers to protect themselves through choice in the market. Now, of course, that's a strong oversimplification of Smith, who's not all the way a sort of purified view, but there's definitely that element there in contrast with the moral economy. So what I want to do then is to talk about two additional moments in this progression that might help us think a little historically, and how each of these traditions exists in parallel and then discursively dialectically with each other. So, as Sanjukta briefly discussed, disruptions that were happening in the 17th century grain market, similar disruptions happen in the latter half of the 19th century. We commonly call it the Second Industrial Revolution, which led to a restructuring of governance, especially at the federal level, because local regulatory regimes were basically just not entirely, but mostly destroyed. But that brought with them, the Reconstruction brought with them certain moral economy norms. And you can see this overall tendency map itself onto consumer protection institutions as well, starting in with the ICC, with the Interstate Commerce Commission, but going well into the New Deal with an evolving set of coalitions that in different ways impose norms of fair dealing and fair price, and quality regulation, which is very common in public markets. So the FDA is a clear example of quality regulation. The Federal Trade Commission is created on terms of, originally unfair methods of competition is its ambit, then unfair and deceptive acts and practices. We can get into the details of these coalitions, but as one way to think about the shift over time is that it's an increasingly national economy, and it's an economy that increasingly accepts that more and more goods are distributed over consumer markets, and sort of increasingly takes consumer markets for granted, but then attempts to impose norms upon those markets in a way that doesn't somehow undermine the fact that they are markets, with some exceptions, right? There's still public utility law, which sort of in some ways takes a good out of the market or really highly regularizes the market. And there's nationalizations of some industries, but not many. And one element of the New Deal that's worth noting is that with respect to consumer protection regulation is that it's confronting advertising, which is a relatively new phenomenon historically. Advertising had existed before, but the possibility of mass advertising, and especially the possibility of creating wants and creating demand, was something that was seen as new and understood as new and was subject to. That was how the FTC got power over advertising in the first place. And then during this time, political economy was reacting against this new moral economy standards to creating what we now think of as the foundations of neoliberalism. So businesses at the time were talking about the logic of consumers as being perfectly, consumers can choose for themselves. Meanwhile, businesses are talking, when they talk to themselves about advertising campaigns, they talk about consumers, being totally manipulable. And this is brought up by people like Robert Lind at the time during regulatory hearings. Meanwhile, free market people like Hayek and Hutt and the like are talking about, not initially with businesses, but talking independently about consumer sovereignty. Originally, it's an idea that's understood as an alternative to more traditional forms of sovereignty, whether democratic or otherwise. I mean, especially democratic, especially post-colonial, as Quinn Slobodian has pointed out with respect to Hutt. But this notion of consumer sovereignty then becomes useful politically as business starts to fund research. And indeed, you can see in the 1940s and 50s a shift towards away from, even within Chicago School Economics Department, away from thinking about consumers as vulnerable to advertising and toward thinking of consumers as presumptively rational. After they start to get funding from a lot of businesses in whose interest that works. So that's like a particular moment, a sort of action reaction. And then just to move forward in time, and I'll end, let's move forward to mid-century. The nationalization and internationalization of markets continues apace. coordination of social provision continues to consolidate. Increasingly many consumer goods are offered via markets. Advertising expands and becomes increasingly important. Indeed, people's identity is very much tied up with how ads tell them to be, or how ads, there's a sort of mutually reinforcing dynamic in the affluent society in a post-scarcity context for a large portion of the population. And the consumer movements in this time are responding to, they're complicated. Some of the consumer movements are invoking economic analysis that was developed, a couple decades before, that was, developed against a lot of these institutions. But other elements of the consumer movement are talking about racial inclusion within markets. So think lunch counters, as Kate will talk about a bit. Think credit and housing discrimination. Think also environmental and public health movements at the time. So the FDA gets a lot more power in the 1960s. Regulation of advertisements for smoking and the like. Those are all part of a consumer movement, and it's an understanding of imposing moral norms on a market, but accepting certain changes that have happened. And then briefly, I'll say, and this time, meanwhile, the sort of innovations of neoclassical economics in the first part of the century become increasingly mainstream within economics departments. And then as economics becomes increasingly influential in policy circles, increasingly just become the language of policy. And so then as people think about reforming consumer markets, they sort of just accept this language without seeing a lineage, a moral economy lineage to the same degree. So looking at this historical trajectory maybe allows us to think about each of these tendencies as distinct tendencies, but both change and both respond to each other. And if we can learn a little bit from the historical, from how they change and how they react, we can engage in our own selective reconstructions. Thanks.
Thank you so much. That was fantastic. Moving on to Professor Steinbaum.
Yes, hi. Thanks for having me. I'm going to try to share my slide presentation, if that's all right. Can you all see that? Yeah, great. So I was really pleased to have the opportunity to discuss higher education and the student debt crisis in this context. I'm mostly here among my antitrust friends, and so they have no idea that I have this other life as a student debt guy. But Luke is one of the few people who is on both sides of my life. So I was glad when he invited me to talk about this subject because I think it's highly relevant to what else has been brought up in this session already, and the ideas of moral economy as opposed to sort of classical political economy or neoclassical political economy. So I wanted to kind of bring up the interpretation of higher education and the student debt crisis with that in mind. And I'm going to start out by talking about that, and then I'll get into kind of the empirical research that I've done about the student debt crisis. And I think, there's kind of, to put my bottom line up front, I think the logic of a moral economy as it relates to consumption is actually really useful to understanding the student debt crisis and public grievances over higher education and the unaffordability of accessing it. We have this kind of dichotomy that Luke just referred to between the idea of consumer sovereignty and the idea of, I guess, state sovereignty or democratic sovereignty that would interpret the sort of defunding of public higher education after the 1960s and the rise of tuition and the transferring of the costs of higher education to students and workers as replacing, a public good that is governed by a democratic logic with a private good that's governed by a consumer logic. And, we're here to kind of look at that and say, that's bad, let's not do that. But I actually think that, we have to kind of get a little bit more complicated, I guess. On the one hand, you definitely get this idea that we're bringing a consumer logic into higher education by defunding public institutions, for example, in books like Academia and Anarchy by James Buchanan. And, this is like formational ideology of the modern era, the neoliberal era, I guess, in higher education. You know, on the other hand, there's basically the opposite of consumer logic coming from this idea of human capital and the skills gap, where rather than sort of consumers choosing between options and picking the one that's right for them, as opposed to just going to their, you know, public universities. So that's like the first idea. Second idea is, you know, going to college is itself abstemious. It's actually saving or investment as opposed to consumption. And what you're doing is foregoing present consumption in exchange for future returns. So that conceptualizes, you know, on the one hand, we have a sort of moral logic of consumption as being good. So if individuals are consuming that, you know, under the Buchananite type idea, that's more morally sound because of its neoclassical economic welfare properties than the existence of a state public higher education system. On the other hand, you know, coming from Gary Becker and the idea of human capital, it's like what is virtuous about higher education is the fact that people are not consuming; they're investing in their future earnings. I don't think that either of these things really works. You know, as an understanding of higher education, I think that, you know, this moral economy of consumption offers us a better framework, namely that, you know, there's a necessary, something necessary for survival is being withheld or rationed at a high price. And the grievance that arises therefrom is the grievance of a gatekeeper standing in the way of the public getting what they need or getting what they want. And on that logic of, you know, that certainly marries a consumerist understanding of higher education to a more public-oriented type of understanding of like how should it be the case that the public gets what they need or gets what they want at a decent price when it comes to higher education? Well, we actually, you know, have a good solution to that. It's public higher education systems that are much more equitably available to the public. I was just, you know, some of these ideas have been I've been formulating in the last couple of weeks. I just the other day listened to this debate about student debt cancellation between Astor Taylor and Sandeep, and Sandeep said something in that debate about how, you know, public higher education systems were inequitable, and so we should understand the increase in educational attainment that has arisen in the era in which they've been defunded as being a kind of blowing up of the old model that allocated everyone to their proper place in the economy, which is to say most people not to higher education, with one that lets many more people in. That's just, you know, I think that kind of conception or self-told history of higher education is common among neoliberal scholars of higher education, and it's just, you know, flatly wrong. If you look at the social background of people who attend different types of universities, our higher education system is much more stratified now than it was when public systems were more robust in the past. And, you know, institutional segregation is a big part of why there is a student debt crisis. We are allocating the best off students to the best resourced institutions. In fact, that brings me to sort of my overall schematization here. This is point number 3 here in terms of causes of the student debt crisis, is that a consumerist system, if we want to understand it that, or at least a neoliberal higher education system, is one that inequitably allocates students to institutions and also inequitably allocates prices to students. So when we talk about, for example, rising tuition in the higher education sector, the usual kind of institutional defense of that is, oh, but nobody actually pays the sticker price except for the people who can afford it and whose parents can pay. Everybody else gets a discount through financial aid. The reality is that who gets what size discount has shifted radically as we've moved from a need-based financial aid system, as it's called in higher ed world, to a merit-based system where the institutions are you know, the concept of merit is a euphemism in the higher education context. What the institutions are saying is, who has other options? We have to, if we want the people who have other options to come to our university, we've got to give them a big discount. People who don't have other options, you know, they're going to pay full freight, and that re-engineers basically who's paying what tuition, such that the price discrimination is inequitable rather than equitable, at least in broad strokes. Now, you know, there's elements of both systems at play, but it's, you know, if we're wondering why it's the case that, you know, there used to be a substantial representation for the children of underprivileged parents at state flagship institutions, and now there isn't, at least in many states, that is a big reason why, is because in order to keep the state flagship kind of intact at all, you have to bring in people who can pay full tuition from out of state, and the people from your own state that you want to bring to the state flagship are the people who can pay full tuition, and kind of relegate other non-traditional students to less advantaged institutions. And then finally, why is it so why, what would I say back to Sandeep Baum, who says that increasing attainment in the neoliberalized higher education system is a sign that it's more equitable than a public one? Why the reason why there's so many more people with higher education attainment now than there were in the past is what I guess I've gone in reverse order here. The phenomenon of labor market credentialization, meaning that more people are pushed into higher education because there's basically no other way of accessing the labor market. So the types of jobs that are available to people who don't have higher education credentials of any kind have dwindled away, and consequently, many people who didn't avail themselves of the public higher education systems back when they were more affordable because essentially it was unnecessary, now are kind of forced into a system that's much more inequitable, and that is layering on student debt for people whose social backgrounds mean that it's going to be them who pays for the higher education, whether it's, and they're not going to get family support. So that's sort of my overall schema for interpreting the student debt crisis. I guess I'll run through some of the data here because, as the economist on this presentation, I can't not present data. So this is all based on research that we've done at the Jane Family Institute using 1 million credit reports in each year from 2009 to 2019 of individuals aged 18 to 35 with some amount of student debt. And then we've matched that to census data about demographics and economics. Here we're basically breaking down the borrowers by race, where the census tract where they live is essentially the proxy for their race, since we don't see the race itself in their credit report. So it's an imperfect measure. But basically what you can see across these charts is the divergence between the amount of student debt people have and the amount of income that people have. And right there, I think, is a pretty strong evidence for why the student debt crisis has arisen and why there's such racial inequity built into the system. We basically require people from minority backgrounds to get more degrees and therefore take on more debt, given that they likely come from less advantaged families than white people trying to enter the labor market. So here we can, again, do this sort of race breakdown by census tract. This is taking the two endpoints of our data set, 2009 and 2019, and regressing the total of the median student loan balance for people in a given tract on the median income for people in the tract. And, this is basically showing an upward sloping line in both cases, or upward sloping relationship, meaning that people who live in higher income tracts tend to have a higher balance on their student loans. So this is what gives rise to what I consider to be the false claim that canceling student debt would be a regressive transfer. On the other hand, between these 2 years, you can see that basically, everyone's student debt has gone up, but in particular, people from lower income backgrounds, and in particular, people from minority race groups, such that now, and now meaning 2019, poor people have as much student debt as rich people did within their race group 10 years ago. So this is the sense in which the sort of the phenomenon of student debt is diffusing across the population, as we have kind of pushed more and more people into the higher education system at the same time as we've cranked up tuition and made the structure of who pays what inegalitarian rather than egalitarian. We can also tell sort of some of like who has student debt aside from this positive correlation between income and loan amount in the cross section by looking at a few other crosstabs, and effect is what's going on here. So we're dividing the census tracts by median income. We've got 4 income groups, and basically we're asking within each income group this is the number of borrowers. So what number of borrowers have which amount of debt? The legend says, what amount of debt we're talking about. So this is saying that, the big green bar that says 234K is saying that people who live in census tracts where the median income is between $20,000 and $40,000, 234,000 borrowers in that who live in tracts of that income have student debt outstanding of less than $15,000. So that kind of finding is what gives rise to the correct assessment that most student debtors are people with a relatively low outstanding balance. That's correct, but it's not necessarily well-off people who have who constitute the bulk of the student of the people with outstanding student loan balances. If you compare instead the total amount outstanding, people who have higher balances account for more of the total amount outstanding. So that makes sense. So this is saying that notwithstanding that more people have lower balances, if we're talking about who has more debt, that's people with higher balances altogether, but it's not high income people with higher balances, or at least as can be measured by the income of their census tract. So saying it's people, people who live in, I mean, this is not exactly plotted by quartiles, but people who live in the second lowest income quartiles that have high amounts of debt account for that $6.7 billion outstanding. I should say these numbers are all within the million credit reports that we have. So 6.7, this is, that's only it's a large number of credit reports, but it's a subset of all the people who have student debt. We don't see all the people who have student debt. And then finally, I wanted to mention this chart because I think this is the best visualization of the segregation in the higher education system that's highly responsible for the student debt crisis. So this is put together by some researchers in the New York City Office of Financial Empowerment. So part of the New York City government's basically an office of the New York City Municipal Department of Consumer Protection. They did this study on student debt within New York City. So we're talking about institutions in New York. And you can see they're essentially ranking the colleges by, the sort of, well, I forget exactly what the top five, this is, based on some other higher education ranking. We've got the top 5 private schools, the top 5 public schools, and then the 5 schools with the highest share of Black students. That's a totally disjoint set of institutions. And moreover, I would say, if you look at the colleges that are on the list of the highest share of Black students, there are 4 for-profit colleges there and 1 part of the CUNY system. Medgar Evers College is basically, as I understand, an HBCU of the CUNY system. If you look at that versus, say, Queens, Hunter, City College, Brooklyn College, or Baruch, all of the top 5 publics are part of CUNY. They're basically is showing huge segregation within the CUNY system. So it's not, when we talk about institutional segregation, a big part of it is definitely for-profit versus nonprofit, but there's also a great deal of institutional segregation within the, quote, traditional nonprofit sector. And these, the sort of color coding that's going on here is basically how likely are the graduates of these institutions, or how able are they to repay debt? So presumably income is what plays in a great deal to setting these this color coding. And this is basically saying, well, the people who are allocated to the institutions whose graduates are least able to repay debt are disproportionately Black, more or less. So that I'll stop there. This is basically just a sort of whirlwind tour of the Marshall Steinbaum interpretation of the higher education and student debt crisis. But I think it does quite nicely fit into the themes of today's discussion.
Absolutely. Thank you so much, Professor Steinbaum. Last but not least, Kate Redburn.
Thanks. Yeah, can you hear me? I'm not using headphones. Cool. I'm going to be really brief because I think we've talked now for a little over an hour, and I know people are eager to get to the main conversation. But I'm going to introduce an area of law that, unlike the ones that have been discussed so far, is a place where the concept of moral economy is very much already out in the open. So in public accommodations law, I think adds something to our conversation about renovating moral economy, including, as was already alluded to, a gentle note of caution. Because unlike areas like antitrust law, that balance between public will and private rights is already completely out in the open. So even people who disagree about what public accommodations law should look like do agree that norms shape and should shape this area of market governance. So a little bit of historical background, I think, is helpful to start off with. Starting in, well, of course, there's the federal law, the 1964 Civil Rights Act, which prohibits discrimination in public accommodations on the basis of race. My research is taking that as time zero. So starting in the early 70s, you also have gays and lesbians in mostly college towns in the Midwest, pressuring municipal governments to add sexual orientation-based protections to their local public accommodations laws. And one of the first was passed in Ann Arbor in 1972 as part of a broader liberation agenda, which was pushed by a local group called the Human Rights Party. And when they were talking to local officials and the press about why public accommodations protections were important, they spoke in terms of the inherent value of gay and lesbian people being able to live openly in all parts of their lives. So someone in the press accurately characterized it as a fight for individual freedom. That probably sounds like what we think of the gay liberation movement in the early 70s. And over time, those laws spread over the country at the city and state level. But an interesting thing happened. In order to convince moderates to join the cause, the gay rights advocates began to speak less in terms of individual freedom or sort of like the basic substantive value, and more in terms of non-discrimination, a more universalizable value. So there were a series of losses at the Supreme Court, which I say in my larger project kind of put advocates on the back foot. And so by the year 2000, you're just much more likely to see defenses of public accommodations protections for queer and trans people couched in terms of non-discrimination. So again, less about the particular advantages of inclusion in civil society, more in terms of the virtues of equal treatment. And here's what I think is most interesting, tracking that same period, is that the values articulated by opponents actually flipped in the opposite way. So as the gay rights advocates learned to speak that language of non-discrimination, the Christian conservative legal movement began to talk about the inherent value in being able to live out their faith in all aspects of their lives. So you have now a move towards individual freedom on one side and away from it on the other. And really the point here is not super sophisticated, it's just to say that even if the debate is properly in the register of morals and not market principles, the ability of particular values to sway power is at best indeterminate, excuse me. And so that's the beginning of my note of caution. The second thing I'll say is that discussing legal conflicts in terms of moral economy can itself obscure important power dynamics. And this might be a place where just different areas of law are different because of the historical trajectories. So I'm not trying to straw man any of the fantastic presentations that you've all just done. But if we look at public accommodations law, hopefully folks are most familiar with the recent case Masterpiece Cake Shop, where there was a conservative Christian baker who refused to sell a wedding cake to a gay couple for their marriage. And in Justice Kennedy's majority opinion, and then a lot of the subsequent commentary, I just read this in the New Republic article from this week, they refer to the conflict in this case as a difficult choice between two competing values, religious freedom and gay rights. And of course, when it's put that way, it's impossible to determine who should win. I don't want to choose between those values. And so when you portray the service providers and their customers as carriers of equally important fundamental values, the imbalance of power between them gets flattened into kind of a standoff between equally, in this case, constitutionally protected truth claims, but you might say just sort of like equally live moral universes. So they're not really speakers of just different truths. One of them is offering services in a market. We might think this is a place where it's a good idea to distinguish between market and society. And more to the point, it shows that we don't necessarily have recourse to anything coherent called social norms in which to re-embed the market. And so that's really my main point, which is just that I worry a little bit that the moral economy frame can assume some unanimity of social values. So whether those are the ones that are frozen in time since E.P. Thompson or Polanyi discovered them, or they're the contemporary moral norms that I think a lot of us share on the panel, there are just a lot of, my point is really just there are a lot of other games in town. And in the absence of basic agreement, that moral economy frame can open up space for those, like the one favoring theocracy that's taking over public accommodations law. So of course we have to identify places where values are clashing behind that smokescreen of economics talk. But putting ourselves in the right playing ground is only the first step. And the second step is building those institutions and the argument. I'm not saying that you guys disagree with this, but just want to put out into the conversation, building those institutions, the arguments and the majority coalition that we would need in order for LPE values to carry the day. So that's my, if you'll pardon me, my 2 cheers for moral economy, and hopefully we'll be able to talk about it more.
Thank you so much to you, Kate, and to all of the panelists. And before we move on to audience Q&A, since Kate responded so directly and sort of challenged some, if not all, of what prior panelists have talked about. I was wondering if anyone has a direct response to how to address a plurality of values that might come into conflict, and how you see that as, and also I'm also curious to hear, just to inject my own theorizing into this, if you can reassert the importance of moral values in the economy without verging into technocracy, perhaps, or into a top-down installation of values. Thank you. If anyone wants to just go at it.
Maybe I'll jump in briefly. Which, you know, one way to sort of avoid a direct specification of all the relevant values would be to say that there might, you know, one thing that moral economy history tells us, and public accommodations history as well, which I think is part of that history. I mean, the common law history also is part of that history, right? In terms of, you know, common carriers and hotels and or innkeepers and the like, is to think about an alternative set of values pertaining to the market, that are nevertheless values that pertain to the market, as opposed to sort of like broad, I mean, they have to be embedded in some other set of values. But they pertain to a particular type of area of life, even if you accept that markets can be constructed differently, and you know, there's not just one sort of market logic, but rather markets are spaces that we construct to be markets. And when we do so, we have certain values in mind. And they might vary a little bit depending on the domain, but one candidate for that sort of value is openness to everyone. Everybody should be able to be a participant on the market, you know, as their full selves, we might also say, although then that gets into this question of religious accommodation. But I think it's just a genuine question, right? I mean, that's like a genuine conflict of values that's worth thinking about as we think about how to construct a market. And there are other, I mean, fair price and fair dealing are other candidates for these types of values that have a little bit of a more complicated valence in how you even make sense of them. But openness to all, I think in some sense is at the principled level, a relatively simple value to accept.
So I don't know if I can jump in really briefly, but I think that Kate's presentation is so well taken in this particular context. I don't know, I don't mean to now respond to Luke instead, but I don't know if this is what you were saying, but I don't think openness to all market participants can be set aside as sort of a separate thing that's more like market logic than these other things. Or maybe that's not what you were saying. But I mean, you do see strains of that, by the way, in the jurisprudence. For instance, in Superior Court Trial Lawyers Association, the FTC, where Stevens specifically distinguishes a boycott of the NAACP as just seeking openness to all market participants, and that's just sort of this simple precondition of having a market at all. Whereas, you know, individual lawyers trying to get paid fair prices for the work they do by engaging in collective action is not. So I mean, I think from a moral economy and LPE approach, we want to resist separating those things out, I think, and not reducing one to the other. But I don't know that one is more. I don't agree with Stevens, I guess, that one can be essentialized in that way. But I want to say one quick thing more, maybe more, not exactly in response, but just in succession or something, which is that, you know, so Luke and I were talking about moral economy yesterday and how thin or thick a notion it should be. And, you know, maybe it's somewhere between the maximally thin of just sort of restating the position that markets are legally and socially constructed and this extremely historically specific thing. But I do want to say that I mean, I actually think we should be pretty specific about meta principles. And I think that we should embrace democracy, both sort of economic democracy and that I think that the idea of sort of democratizing economic organization or democratizing the legal allocation of economic coordination rights, I think does, you know, go to both sort of the actual sort of what forms of economic organization result, but also sort of like questions about like seemingly separate questions about process, insofar as Congress and potentially administrative agencies are actually closer to democratic will than judges. And not that there's sort of one perfect answer there. But I want to say just really briefly, and that this is not in the paper, but I think that the historical concept is useful, because I think that the way in which the Chicago School, I would argue ultimately, I have not yet argued, but will argue, sort of is the newest articulation of a defense of a master-servant economy. Because ultimately, and I didn't talk about this, but ultimately, what justification you do have for conventionally organized firms goes back through Williamson and Coase to literally master-servant law, right? And then, but now gets naturalized as efficiency, right? And so, but that goes back further, even to the dialectic within the 18th century moral economy between repressing journeyman organization and accommodating the consumer movement. So I think that and we should look at things besides England, but that happens to be where we get our system. But I think that this opposition between master-servant economy and democracy and fair competition, I think, arguably goes back further.
Yeah, I'll just add a couple of quick points following up on what Sanjukta, Luke, and Kate said. But the moral economy did have a strong non-discrimination norm, as Luke mentioned. The law of common carriage, law of innkeepers, duty to serve all comers, and in instituting Jim Crow across the South, state governments actually statutorily repealed the common law to allow hotels, restaurants, and theaters to discriminate on the basis of race. So they were really coming up with something new that represented a break with the moral economy norms. And, in fighting Jim Crow through litigation and other means, civil rights lawyers did draw on the moral economy tradition to say that, historically, hotels had an obligation to serve all comers. They couldn't discriminate on the basis of race. This is a recent statutory innovation. We're trying to go back and build on this older tradition. And it actually comes up, interestingly, in antitrust debates today, where the Chicago School view of antitrust is firms have no duty to deal with other parties. They have complete discretion over who they sell to. And they've said this applies to monopolists as well. So monopolists can refuse to deal as a means of extending its dominance from one market into another. And as a strictly descriptive matter, that's not true. We have the Civil Rights Act, we have, the common law of innkeeping, common carriers. So they are trying to, in a sense, build on this Jim Crow norm that firms have complete discretion over who to transact with. Obviously, they wouldn't explicitly say that firms cannot deal with people on the basis of race or gender or sexual orientation, but there is an interesting ideological through line there.
Yeah, I basically agree with all what's been put forward as an answer to the interesting points that Kate brought up, especially Sanjukta's invocation of master-servant law as the basis of the ideological lineage for departing from moral economy. The idea that I would just say that kind of points the way to what is a universalizable principle, at least in my view, which is basically an egalitarian principle. I mean, in some cases, that's not going to be able to accomplish everything we want it to, like in the case in Masterpiece Cake Shop. That doesn't, my interpretation would be it doesn't offer up the solution there. But in other cases, like free entry, or basically everybody has to have a voice or a space, that could be bad. I mean, as Sanjukta is alluding to, in the labor context, that is an anti-worker point of view in a lot of cases. And as we have dealt with repeatedly in the gig economy, the idea that there should be limits on entry, and those limits should be at the discretion of the workers, or of some sort of public authority, as opposed to of the platforms, is like, oh, you're destroying the free market if you say that, but that is absolutely an egalitarian principle in that context.
Let me just say something very briefly and then we can go to a question, which is that like maybe what this points to is that I was too quick to say we're talking about norms of the market, but in fact, what we're talking about is we have to look at the substantive, area of, rather than thinking about the labor market or the consumer market, we have to think about, if we're talking about access to a place to stay for the night, a hotel, if we're talking about access to, supplies for your wedding, there's one set of norms that pertain to that, with respect to, everybody should be able to access it on equal terms, although we'd have to get into the question about what equal terms means, or at least in principle, everyone should be able to choose to access it. Whereas, if we're thinking about labor governance, that there's a different set of principles that matter, and it's not actually helpful to think about them as both as markets in that sense.
Thank you all. So we see how quickly debates can unfurl and how varied the conversation gets depending on what level of specificity we look at the market broadly, the economy broadly speaking through. I'm going to, since we have about 10 minutes left in what the planned panel was, how we planned the panel rather. So I'm just going to move on to a panel, audience Q&As. Starting with one that's been upvoted a few times. How do you think about, and this is for anyone, how do you think about the potential conflicts that are likely to arise or not when establishing socially coordinated prices or wages between unions and consumers, small business owners versus consumers, et cetera? To, I guess, rephrase, this sounds like it's gesturing towards something that the panelists just talked about, which is potentially conflicting values. And if anyone wants to say something specific about prices and wages and that conflict that's often been brought up by, I think, neoliberal economists as well, please go ahead and address that.
I don't know that I have like Marshall.
Sanjukta, you go ahead.
Well, okay, so I'll just say one quick thing. I won't try to address it comprehensively. I think it could certainly be a longer discussion. But I mean, of course, we saw versions of this arise in the little experiments we've had with sort of much more express. I mean, I would argue we are socially coordinating prices and wages now, but we're just delegating that coordination to the top level firms in the economy, and specific control groups within those firms. But in the experiments with sort of somewhat more democratic social coordination of prices and wages that we've had, so for instance, in the early New Deal, actually what we saw, right, was conflicts not so much between consumers and workers or between small business and workers, but more between big business and labor and big business and small business. And I think that there's a pretty compelling account of NERA and why everyone hated it in the end is that it was captured by big business. So I really wonder how, I'm not saying there won't be conflicts and that it'll all just be this idyllic thing, but I also think we should resist the idea that everything is zero sum and that market stabilization can really benefit consumers, actually, right? Like crazy destabilized markets are not good for consumers. That's why we end up de facto governing those markets as well. It's just that even our so-called really competitive markets with atomized participants, the example I keep coming back to here is sort of pre-gig economy, is really small trucking companies in local and regional markets, which are effectively controlled by the buyers of trucking services. It's not that there's a level of instability in those markets that benefits the buyers, and that's why that is sort of tolerated, I think. But there are also a lot of sort of broader social harms that are not efficient in any sort of operationalizable sense. Anyway, so I think that's all I'll say.
Yeah, I knew Sanjukta would say basically what I thought, so I'll thumbs up all of that and basically say the same thing again in slightly different language, which is that I think, having heard this sort of objection, like increasing the minimum wage would be bad for consumers, or, Walmart is good for consumers, but it's bad for workers. That kind of like, oh, we have these values and we have to choose between them, I basically wholly reject. I think the type of place where we have difficult conundrums between values or constituencies is what Kate referred to in their discussion. I think democracy and egalitarianism basically give us the right answer in all of the cases that are outlined in this question. And I think, to return to the higher ed case, there you could say like, okay, well, if we eliminated tuition for higher education, then that would be terrible for professors. That would lead to rampant adjunctification, and we have seen that in some institutions that have sort of stood against the tide for higher tuition. They're like the worst when it comes to adjunctification and poor quality of education for grad students, for example. But the sort of shining example of like the California master plan, you've got no tuition, and the heyday of public good job quality, of the ability to do research unencumbered by kind of political considerations. I mean, obviously that wasn't true. They had loyalty oaths throughout the California master plan, but we can see types of institutions that really are responsive to all of these logics, and don't have to choose between them. Like, there are places where we have to choose between them, but I feel like democracy and egalitarianism, make it easy to choose in other ones that are the commonly brought up as the hard choices.
Yeah, so I would just quickly add that I think one of the political masterstrokes of neoliberalism has been hiding the pricing power of corporate monopoly and oligopoly, and playing up the supposed tension between workers and small producers on one hand and consumers on the other. And in some cases, even saying that big business and consumers are in it together against workers and small business. So I think Uber is a really good example, where Uber created this narrative that it was disrupting the quote unquote taxi cartel and delivering more affordable rides and convenience, and shaking up this sclerotic business. It's not actually what's happening, but I think they created this narrative, and it was widely accepted by many people. And we need to really push back against that and say, the problem today is corporations have too much pricing power and everyone else has too little. And yes, there are theoretical conflicts that we might have to confront down the road between unduly powerful unions and unduly powerful worker cooperatives, but it's not an immediate concern. And to the extent it is a concern, it just highlights the need for some form of public oversight.
Well, can I just add briefly, having chastised everyone for relying on historical antecedents, that there's a really good historical antecedent for what you're talking about, which is, of course, the early 20th century Labor and Consumer Alliance, which, you have the National Consumer League with chapters all over the country, working really closely with labor unions to try to, they talked about it in terms of purchaser power. So purchaser power is the way that the pocketbook in the home links the paradigmatically wife going out to buy things with the paradigmatically husband, who's a member of the labor movement. So the tension, I mean, of course, as you've already said, the tension between those things seems really apparent because of the ideological changes over the course of the 20th century, but there's a fantastic example from not very long ago of those interests being very closely aligned to great effect. So,
just to say one, sorry.
I was like a 2-second thing on the example that Sandeep gave, which is great points. Just that, of course, also Uber has, and I want to both say that they've misused this, but also it's also to like maybe reiterate the caution too, that we can't forget the egalitarian and openness element to this too, right? Which is that, of course, Uber has also said that part of that disruption is opening up access, and has used the language of racial liberation, most recently in the context of Prop 22, really cynically, I think. But then to the extent that, but also we're responsible for making sure that our alternative institutions really are open and egalitarian.
Yeah, I just wanted to briefly add, like, the the consumer often comes in as the interest that, neoliberalism is always really, we're talking about worker protections, we're talking about like, openness to capital, like in developing countries, we need to provide cheap consumer goods and like, and like the thought there is always the consumer interest is low prices. And I just want to resist that notion of what the consumer interest is. Low prices are good for a lot of things, but first of all, there are costs to low prices, societal costs to low prices. And second of all, like there's trade-offs, within consumers, even just within an economic framework, price and quality, like everything but price, which can somehow also be priced, is a trade-off. But, when we're talking about things like, anti-discrimination in the market, that's not like, it's a non-price element of the market. And so anyway, there's multiple conflicts of interest that happen at multiple levels, and how we construct the market and the overall social provisioning process is always balancing those interests. The only two interests aren't low price and like workers being able to live.
That's fantastic. Thank you all. I know we're at time, but there are some more Q&As from the audience if anyone needs to go. Completely understandable if any of the panelists need to head out. I will ask one more question that is directed at Sandeep and Sanjukta. So if either of you have to go, either just shake your head vigorously at me, or I'll ask it instead. So this is from the audience. English contract law has occasionally flirted with the doctrine of inequality and bargaining power, which has been difficult to reconcile with the rest of the law. When moving past self-regulating market principles, are there other potentially similar principles that should govern how a society should allocate economic coordination rights or regulate contract terms other than political choices? And if these sorts of principles exist, how can we reconcile them with other areas of the law? This may go back to many of the points that you've touched on today already.
Yeah, I could start just really briefly. So I think that it wouldn't necessarily be an alternative to political, like I think it's going to be political no matter what, but I don't think we should stop there. We can say more about what that choice should be. So I think that, so I think like two good meta principles for antitrust law, and then more broadly, perhaps for those other areas of law that I mentioned, would be to disperse or dispersing economic coordination rights rather than concentrating them means moving in the direction of economic democracy. So they're synonymous. But I think that's one meta principle. And I think the second meta principle is affirmative norms of fair competition, which obviously have to be filled in, but that would apply sort of regardless of the sort of the extent of coordination rights you already enjoy. So regardless of whether you're a dominant firm or a smaller market actor. But I just want to say on the idea of inequality of bargaining power, and maybe there are labor law scholars who in the audience who want to disagree or add to this, I'm not sure. But I think that if you look, for example, at the way that American labor law at least thinks about it, so inequality of bargaining power is at the heart of the Wagner Act scheme, certainly. But it's really interesting because if you look at the preamble to the Wagner Act, it indirectly refers to the allocation of coordination rights and to the firm exemption, and actually says, there's not some like sort of mysterious other type of inequality of bargaining power. Of course, that can arise for circumstantial reasons or for other reasons, right? But that there's already this inequality, this fundamental inequality of bargaining power that at least labor law is seeking to redress or partially redress, lies in the coordination rights that owners of capital already enjoy through corporate organization, and that this is explicitly, so I'm indirectly answering the question, but I'm saying that, there's also that the concept of inequality of bargaining power, I think, refers back to the allocation of coordination rights in a way that I think has been acknowledged in other parts of the positive law. And so anyway, those are so I would say that the principle should be to disperse rather than concentrate them. And obviously that has to be operationalized a lot further in particular areas of law, and there's different mechanisms for doing that.
I'll just very briefly, oh, sorry.
I was just going to briefly add to what Sanjukta said and note that in American law, we've had this doctrine of unconscionability, which is a defense against enforcement of certain contracts on procedural and substantive grounds. Unconscionability is often held up as this progressive doctrine in law school, but I think in the grand scheme of things, it's relatively weak tea. First, it's only a defense, and it's increasingly available under very limited circumstances. So I think we need to think more expansively. And New Deal post-war antitrust, I think, is actually a pretty good model in that it did embody, among other things, an anti-domination principle, whereby firms had limited power to control suppliers, distributors, other trading parties through contracts, known in antitrust as vertical restraint. So, for example, in 1960, McDonald's, the franchisor, could not dictate how McDonald's, the franchisee, conducted its business the way it does today. And the rise of the fast food franchising model is due in large measure to revisions to antitrust law that liberalized the use of vertical restraints. And Marshall and Sanjukta have written a great deal about this. And so I think recovering this anti-domination principle is an important part of the antitrust reform reconstruction project.
So just to pick up on unconscionability, really nice segue. One way I've thought about, on the consumer law side, one way I've thought of unconscionability, because it often comes up in consumer contracts, is like as compared with like FTC enforcement, or like setting substantive standards for what should go into a contract or which contracts are unfair, and the like. And if you think about unconscionability as existing alongside other potential ways of dealing with inequality of bargaining power, as Sandeep and Sanjukta both highlight, it's less whether the common law should address inequality of bargaining power, and more like our courts, is the way that courts can engage with the inequalities that are produced in a market apt to deal with the phenomenon. And unconscionability is a limited, in some states actually you can assert it affirmatively, but part of the issue is just that it's like a case-by-case adjudication approach is often not going to do a very good job at actually dealing with balancing the relevant interests. It's only going to just sort of say, hey, this looks bad, we need some like short-term remedy, rather than sort of rethinking the way the whole thing is working.
Well, if no one else wants to chime in on that point, at this point we're 7 minutes over time. So thank you very much to the panelists for staying on. Thanks to all the attendees, the Law and Political Economy Society, for organizing this. I found it to be an absolutely fascinating talk. And the talk itself will be posted on the LPE website soon. And yeah, thank you all so much. It's been wonderful to be here with you all.
Thank you so much for having us. This is great.
Yeah, thanks, Ella.
Yeah, this was fun. Next year in New Haven, I guess.
Thank you, Ella, for wonderful facilitation of an unruly panel.
We're very well behaved by our usual standards.